Well, we have made an objection that the tribunal should not proceed to hear and determine this matter. And we have given reasons and grounds for our application. The grounds are: one, that there are criminal proceedings pending in the magistrate's court, and those proceedings have not been completed; that Mr. Duncan, under Article 144 of the Constitution, is entitled to a presumption of innocence. That presumption means that he is innocent of the charges until he is proven guilty. That to establish a tribunal to investigate his removal from office on the mere institution of a charge and before the determination of any guilt is an infraction of that constitutional protection which guarantees him innocence until he's proven guilty before that tribunal. And therefore this tribunal is premature and is an infraction and a violation of that constitutional protection. That's the first point. The second point is that the letter which the Prime Minister allegedly sent to Duncan sometime in March, calling upon Mr. Duncan to show cause why this tribunal should not be established, that letter was never received by Mr. Duncan. That we have checked at all the offices and home of Mr. Duncan. We have checked at the post office, and there is no evidence that such a letter was ever sent. I wrote to the Prime Minister and I asked him to state the date, time and place where this letter was delivered, to whom it was delivered, and to produce any evidence whatsoever that would tend to establish that this letter was either sent or received. The Prime Minister never answered those questions. All he did, his office did, was to send me the letter that was purportedly sent. The law is very clear since the decision in Barnwell case some 20 years ago that before you remove certain office holders in the Constitution, which requires the triggering of this process, which is the process used to remove Mr. Duncan, even before you start the process, Mr. Duncan is entitled to be heard. And that letter that was purportedly sent was supposed to have extended that facility to him. That letter was never sent, that letter was never received, and that fair hearing that Duncan is entitled to even before the recommendation is made to the President to establish this tribunal, that was never accorded to him. And that makes the tribunal bad, makes the tribunal infected from its very beginning and a nullity. And that's exactly how the Barnwell case was determined. Then the third ground is that Mr. Duncan sits on the Judicial Service Commission. The chairman of this tribunal is a sitting High Court judge. The other member of the commission, Mr. Justice Patterson, is a retired judge. Mr. Duncan, as a member of the Judicial Service Commission, exercises supervisory jurisdiction over judges. He did it in relation to Mr. Patterson, who is now retired, and he currently exercises such jurisdiction over Justice George. And therefore it is improper for a member of the Judicial Service Commission to be judged, essentially, by a judge.